Welcome to Week 2's Advance or Asynchronous lecture. It will introduce 4 hot-button issues facing U.S. culture and therefore our church: contraception, abortion, same-sex relations, and transgenderism. Your reading materials consider the state of the argument, if you will, the arguments for acceptance of each of these things, the secular arguments. But in the course of the arguments for them, you will see more than a little of the problems with accepting any of them. That is, you will see the weaknesses in the arguments, even considered from purely logical, non-religious perspectives. In this brief advanced lecture, I want to give you some historical background on each of the topics, so that you can even better appreciate, especially by distinction from the not-so-distant past, where we are today. I take you through the history of the law in particular, and not just because I'm a law professor. But this law was both responding to culture and influencing it, beginning with the 1965 Supreme Court contraception opinion through the 2015 same-sex marriage opinion. Law has played an outsized role in our social transformation, and rather than have you read too many legal materials, I do have you read a few, I've decided it's better to offer you a summary in lecture form. So, first, regarding contraception. In the United States, contraception was explicitly illegal in the 19th century, largely as a result of laws called Comstock laws, named after their federal sponsor. That illegality persisted through the early 20th century at the state level until the early 1960s, and remember, the pill debuted in 1960. At that point, very few states still had such laws on the books. Eventually, one of the last, or perhaps the last state with a law making contraception illegal, including for married couples, was Connecticut. This law was challenged by doctors associated with Yale University and Planned Parenthood in a case that came eventually to the U.S. Supreme Court entitled Griswold versus Connecticut. Plaintiffs, that is, the people who are complaining, asked the court to find that even though the federal Constitution said nothing explicitly about contraception, its guarantees of things like liberty, a word in the 5th and 14th Amendments, and other constitutional provisions, like provisions about citizens' rights not to be subject to searches of their homes, that these were broad enough for the court to read into the Constitution a right of married people to buy and to use contraception. The Supreme Court agreed. It wrote in that opinion, again, Griswold versus Connecticut, that, quote, the penumbras and emanations, unquote, of various constitutional provisions created a zone of privacy that protected married couples' private decisions, because after all, they were a married unit, and especially protected their bedrooms from state interference. But a quick 7 years later, as the 1970s progressed, and what came to be called the Me generation was gaining strength. Interestingly, in a case involving a doctor, Bill Baird, who would go to Catholic universities and distribute contraceptives to the students there. This case came to the Supreme Court as Eisenstadt v. Baird. In that decision, the court held that the right of privacy pertaining to contraceptives didn't just cover married people, but also covered single people. It said explicitly that marriage was not a unity of persons, but two separate individuals with separate minds and hearts, possessing privacy rights to make individual decisions about matters so fundamental as the decision whether or not to bear or beget a child. Note what happened here. Privacy moved from the married couple and from their bedroom to inside people's heads. It pertained to what the court said were the really important personal decisions people would make, like whether or not to have a child. This wasn't even any longer considered a joint decision of the man and the woman. No coincidence then, shortly after, in 1973, the Eisenstadt case's language was cited in Roe versus Wade as part of the Supreme Court's invention of a constitutional right of abortion, despite the Constitution saying nothing about abortion, but rather indicating in the 14th Amendment that all Americans possessed a right to life, liberty, and property. In Roe, the court flat out held, however, that the 14th Amendment's liberty guarantee contained a right of privacy broad enough to encompass a woman's right to abortion throughout pregnancy. A lot of people don't realize that this was the holding. Even in the third trimester, no state was permitted to forbid an abortion sought for reasons of life or health, with health defined, and I'm quoting, as all factors, physical, psychological, emotional, familial, or the woman's age, relevant to the well-being of the patient, unquote. In other words, any reason at all. Why was abortion part of a right of privacy? Well, the court's explanation was not reasonable, but it's important to understand it. It concluded that women's hardships when they did not want to be pregnant, that is, they were embarrassed of being single, they were in psychological distress, they were physically uncomfortable, they were worried about a disabled child, that all of these were more important than what the court unscientifically called potential life or only fetal life. In short, Roe began 50 years of legal and public conversation about abortion as a path to women's freedom because it freed them from the burden of children. Case after case expanded upon this until we got to the awful 1992 Supreme Court decision in Planned Parenthood versus Casey, wherein the court held that liberty in the Constitution protected individual choice, and here I'm quoting, in matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy. All of these are central to the liberty protected by the 14th Amendment. It concluded, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Completely subjective, sexual choices are what constitute your identity and shape your universe, said the court. And the Constitution has to recognize an individual's subjective choices in these arenas as a matter of its liberty guarantee. This is the language, and these are the concepts you will see in the Dobbs dissenting opinion, which I have assigned you. Dobbs, of course, overturned Roe versus Wade, but I have you read the dissent. It is the language of pure autonomy. It denies that human beings are interdependent, in even very vulnerable human beings. And it speaks as if human life before birth has zero weight or value, because adults may choose to conclude that as part of their subjective identity and universe shaping, the child has no value. This language about sexual and parenting choices as identity forming and universe shaping then became, in 2003, the basis of the Supreme Court's decision that same-sex sexual relations are constitutionally protected because they too are universe and identity shaping. This was the Supreme Court's case of Lawrence versus Texas, wherein the court also suggested that any laws purporting to regulate sexual choices would be struck down as violation of a person's constitutional privacy and liberty. The court opined that the state has no right to take a position about these sorts of private moral matters. No surprise then, the reasoning in Casey and Lawrence then becomes the basis for the Supreme Court's holding in its 2015 decision, inventing a constitutional right of same-sex marriage. This is the case of Obergefell versus Hodges. Oddly, after discussing contraception, abortion, and same-sex relations as privacy rights, the court held that this same constitutional right of privacy required the state to give public recognition in the form of a marriage license to two persons of the same sex who wish to declare marriage vows to one another in the public presence of a state-recognized officiant. In Obergefell, adults' sexual autonomy reaches new levels. To wit, the court deems adults' interest in same-sex unions to be so critical that no state thereafter is permitted to declare that there is something especially good or desirable for the state about procreation, or about procreative unions, that is, unions of men and women. And no state after Obergefell can favor family structures in which any children involved would know or be known by their natural parents over family structures, that is, same-sex adult pairs, in which in every single case the child is to be separated from one or both natural parents by means of assisted reproductive technology, adoption, or the child's having been conceived in a prior heterosexual relationship. In the Obergefell excerpt I assigned you, you can see the court's reasoning in favor of adults' autonomy. to the point that it becomes ironic to read so much about individual self-realization via a choice to get married in a state-recognized marriage, in an opinion supposedly about marriage. All of these cases, prior to the Supreme Court's overturning of Roe in the Dobbs case in 2022, paved the way for the conversation the nation is having today about transgenderism. These cases invented a constitutional right of privacy that eventually became a right to autonomy, which means a law unto oneself, which was eventually described as the power to shape one's own identity, which is, of course, the leading claim underlying the transgender movement. Notice a few things that these Supreme Court cases I've reviewed with you have in common. First, how so many of them ignore science. For example, the humanity of the unborn child, or the agreed importance for child welfare for children to be raised by their natural parents whenever possible. Notice, too, how many of these decisions ignore children's interest in life itself or in knowing their parents. Children are instead characterized as inconvenient or even dispensable. What they are not seen as in these cases are human beings with the right to life, with the right to be cared for by their parents, and also to be cared for by the state should their parents prove unable. This is how we got today to the point where children's right to, quote, change their sex, unquote, is championed, as against their parents' wishes. Ironically, it's a right championed by the very people who would be content to see these children aborted at the beginning of their lives, with their parents to desire that. The common thread of reasoning? Autonomous sexual choices claimed to be identity shaping by whomever is wielding the right must win. In sum, the story of the current championing of contraception, abortion, same-sex unions, and transgenderism is a wholesale rejection of the Christian way of love, which involves radical solidarity, especially with the vulnerable, and a respect for creation, as well as for reason. We will explore these materials in the next classes 3 and 4.